as an alternative dispute resolution, protocols by leading arbitral institutions promoting and facilitating virtual arbitration, institutional push towards e-arbitration, which is much required, I believe, position of law in India aiding e-arbitrations, key issues pertaining to e-arbitrations, and of course their advantages. So I will now hand it over to Utsav to proceed with the presentation.
Thank you, ma'am, for such an introduction. Good afternoon, everyone. So taking it forward, yes, thank you. Taking it forward, let's talk about the shift from the traditional arbitration to a new technology-based arbitration in India. Like any other industry, for example, the service industry, the manufacturing, etc., the judicial system, each industry faced its own problems, and arbitration is not an exception to that. However, because of the underlying object of arbitration being the party autonomy, the cost-effective and time-bound settlement, arbitration has found its way to a new, modern technology-based arbitration. Many leading international arbitration centers, such as the London Court of International Arbitration, SIAC, Hong Kong International Arbitration Center, have introduced new protocols, guidelines, and rules to mitigate the effect of COVID-19 and took a step forward to modernize arbitration. Special arrangements, rules have been introduced for conducting arbitration proceedings remotely, filing of submissions, cross-examination, etc. For example, the London Court of International Arbitration has amended its rules permitting arbitrators to expedite the proceedings, permitting the parties to have online hearings, and confirming and facilitating electronically signed awards. International Chamber of Commerce has similarly introduced new system to facilitate virtual arbitrations, signing of documents, exhibits, etc. So, just like that, Singapore International Arbitration Center has actively promoted the use of technology to conduct virtual arbitration by training the stakeholders. Moving on, with the modernization of arbitration internationally, India has introduced its own new sets of rules and regulation, and there has been a major push towards e-arbitration in India. Back in 2014, the Law Commission of India encouraged the use of technology such as video conferencing, teleconferencing to aid the efficiency of online arbitration proceedings. Niti Aayog, which is a public policy think tank of the Government of India, similarly promoted online dispute resolution, ODR in India, which involved senior judges of the Supreme Court and the other stakeholders of the industry. The Indian Council of Arbitration, ICA, is a leading arbitral institute in India, which has introduced new rules that permit the arbitrator to conduct arbitration proceedings by video conference, telephone, and such other means of communication which may be feasible and deemed fit. Similarly, the Indian Arbitration Forum has brought in new rules permitting the arbitrator to conduct virtual cross-examination, virtual hearing, that would allow India to match the international standard. Now coming to the position of law in India as on today. So the Indian arbitration is governed by the Indian Arbitration and Conciliation Act 1996. As of today, there is no particular law which provides for e-arbitration in India, and neither is there any bar which restricts e-arbitration in India. Section 19 of the Arbitration Act provides the parties and the arbitrators to decide on their own procedure. It further states that the Civil Procedure Code and the Indian Evidence Act is not applicable to arbitrations in India. Therefore, the arbitrator, considering the request of the parties and the need of the parties, can decide on its own procedure by conducting e-arbitrations. With the modernization of arbitration internationally, India has introduced a new set of regulation and legislation. For example, Section 29 of the Arbitration Act provides for a speedy and expeditious arbitration proceeding, mandating the tribunal to pass an award within 1 year. Similarly, Section 29B of the Act provides for an award based only on the written submissions without the need of having an oral submission. There has been a dispute with regard to e-arbitration, that is confidentiality and privacy issues. India has somehow tried to counter that by introducing Section 42, which provides for that the stakeholders have to maintain absolute confidentiality in matters of arbitration. However, at this point of time, we cannot say with certainty that it would be an effective measure, since there are no penal provisions attached to it. If you breach confidentiality, there's no penal provision or cost. So therefore, in India, legislature will have to work upon it. Now, certain issues that pertains to e-arbitration in India, as I just discussed, security and privacy concerns. We all know what happened between the issue of China and the recent privacy issues and hacking the system. So therefore, Section 42 will have to be amended accordingly to make India e-arbitration safe. Next is expenditure on infrastructure. We all know in India, arbitration has just reduced tier 2 and tier 3 cities. However, lots of cost will have to be explored to make arbitration, e-arbitration in India. Next is the training. So in India, most of the arbitration are ad hoc based. And most of the arbitrators in India are retired judges of the High Court or of the lower courts. As I said, back in 2014, a recommendation was made by the Law Commission of India promoting e-arbitration. However, that was not accepted wholeheartedly by the stakeholders because of the shifting because of their expertise and because of the because of them being used to traditional arbitration. However, therefore, a lot of expenditure will have to be made and for training purposes. Now, coming to certain advantages of e-arbitration. E-arbitration promotes time-efficient and focused hearings. It encourages a consensual approach rather than an adversarial one. Number two, it allows for a flexible dispute resolution process where parties can tailor their proceedings according to their requirement. Number three, a remote forum allows proceedings to be scheduled in a timely manner and avoids the cost associated with the travel and accommodation. Number four is the sharing of knowledge and expertise. E-arbitration permits practitioners, arbitrators, and parties to appear and assist the tribunal from any geographical location, bringing global perspective and knowledge. Now I would like to call Vidula ma'am to conclude and provide valuable suggestions.
Thank you, Utsav. Bharti has just informed me that we are already ahead of our time, but I would like to take this opportunity to thank Team LexTalk for allowing Vardharma Chambers to be a part of this beautiful legal conference. And just one thing I would want to add before I step down, that since I'm a person who is, very, very involved into environmental law as well, I know this is off topic, but since I'm on a global platform, I just want to make the statement that in case we shift from paper to paperless online dispute resolution, then there will be a lot of environmental benefits. And just a fun fact, about 11 billion sheets are being used globally for dispute resolution, and the growing cost for it is about 1.3 billion trees are being cut, 109 billion liters of water is being used, which is affecting the environment, which is why we're facing pandemic and etc. certain epidemics like these, which will come up in future. So I think being lawyers, shifting from alternative dispute resolution to online dispute resolution will also affect our environment a lot. Thank you to LexTalk. Thank you everybody for your patience, and thank you for listening to us.